now. First, welcome everyone to the second Camp Santiago Conference International Commercial Arbitration and the CISG. We are really thrilled to have you all participating today with us from different time zones, right? Today we will have a world-class panel that will be addressing some of the hot topics and discussed in the Vis Moot of this year and in the practice. The first part of this activity, we will have the welcome remarks from our president of Camp Santiago board, and then we will switch, we will continue with our conference to listen our executive director and our dear guests. So Mr. Chadwick, the floor is yours, please.
Thank you, Laurie. Well, good morning for all our friends, and especially to all the panelists of today. On behalf of the Board of Directors of the Camp Santiago team, I warmly welcome you to the second conference of the Camp Santiago on International Commercial Arbitration and International Sale of Goods, organized by the Office of Study and International Relations. The Arbitration and the Mediation Center is not a profit institution. It was founded in '92 by the Santiago Chamber of Commerce, with more than 5,000 cases of arbitration and mediation. In the first 20 years of its existence, Camp Santiago has become a leading institution in the adequate resolution of conflicts in Chile and Latin America, providing reliable and efficient solutions to the business and legal community. In its story, Camp Santiago has undertaken numerous projects and activities aimed to the dissemination, research, and improvement of appropriate methods of peaceful conflict resolution, providing constant support to the legal community and college students. In this context, and after the success of the first edition in March 2020, today we celebrate the second conference of the Camp Santiago on International Commercial Arbitration and International Sale of Goods. Today, we will have guests who join us from Austria, Switzerland, Italy, and Germany, who will share with us their views on the following topics: the Vis Moot, the Swiss Chamber's arbitration, is there a right or physical hearing on international arbitration, the seller liability for infringing goods under the 42 article of the United Nations Convention of Contract on International Sale of Goods. The issues are very important, not only for the student who will participate in our Vis Moot next week, but also for those who will participate at the end of March in the Willem Vis Moot, and for lawyers who are engaged in international commercial arbitration, acting as arbitration and counsels. Since 2013, our center has been pioneer in Chile and in the world for having a platform for digital processing of our arbitration and mediations, which serve the foundation for more than 1,200 online hearings during the COVID-19. Avoiding this matter, the paralysis of arbitral proceeding and allowing about 80% of arbitration continue. With the above, the center strengthened arbitration as adequation mechanism for the peaceful resolution of conflict and Chile's increasingly important arbitration seat in Latin America, capable of adapting to the needs of the party and respecting the warranty of the process. We hope you enjoyed today's conversation and that we can meet soon in Santiago de Chile, our city. Without further, I give the floor to Macarena Letelier, that is the best important person today in the team of Camp Santiago. Thank you for all.
Thank you very much, Herman, for introducing remarks and opening comments. As our president commented, the Santiago Arbitration and Mediation Center, Camp Santiago, is a non-profit institution established in 1992 by the Santiago Chamber of Commerce, and over the year it has become the Chile's leading dispute resolution organization, as you know. Today, we meet remotely nearly or more than 100 people and from all over the world to analyze some of the issues that are discussed in the problem of this year's Vis Moot. the world's largest, and most renowned law students competition in the field of arbitration. This is the second year that we are working in this. And we are very fortunate to host this webinar with 4 leading practitioners in international commercial arbitration and international sales of goods from Australia, Switzerland, Germany, and Italy. You know that our president, Herman Chadwick, is also the president of ENEL. So he is very, very near for Italy all the year. We always are fighting to have him more than Roma and Italy. Nevertheless, we do ask the attendants and the students to refrain from asking very specific questions as to how to resolve these Vis Moot issues. But we encourage you to ask your questions through the Q&A section, and we invite you just to be brief and precise. This Vis Moot is the most prestigious arbitration moot, and it is a fascinating experience for students, lawyers, and arbitrators from all over the world. This moot was first suggested at the UNCITRAL Congress on International Commercial Law in 1992 in New York in order to promote the United Nations Conventions on Contracts for the International Sale of Goods. The goal of the Vis Moot is to foster the study of international commercial law and arbitration for resolution of international business dispute through its application to a concrete problem of a client and to train law leaders of tomorrow, I think of today too, in methods of alternative dispute resolution. Almost 28 years ago, Professor Eric Bernstein, Professor Albert Krisner, and Professor Willem C planned the first edition of the Vis Moot, and over the year, it has become a unique educational experience for students, lawyers, and arbitrators. Given the large number and diversity of participating countries, Vis Moot events are organized in almost every continent, and last year our team at the Office of Study and International Affairs, who leads Mrs. Laura Aguilera and Claudio Oces joining together, organized the first Camp Santiago Vis Moot and the first Camp Santiago Conference on International Arbitration. To know more about this Vis Moot and its impact on the law practice and in the next generation, today we are honored to have Mrs. Patrizia Netal. Hi, Patrizia. Thank you very much for joining us today. We will begin with Patrizia. Patrizia, Mrs. Netal, is co-director of the Willem C International Commercial Arbitration Moot, co-founder and partner at KNOETZL, a leading Austrian firm specialized in arbitration, litigation, and alternative dispute resolutions. And since January 2020, Patrizia is member of the board of the Vienna International Arbitration Center. Patrizia practiced both as counsel and arbitrator. She has extensive experience in institutional and ad hoc arbitration proceedings, including the rules of arbitration of the International Chamber of Commerce, ICC, the rules of international arbitration of BIAC, Vienna rules, the German Institution of Arbitration, and UNCITRAL arbitration rules. We hope, Patrizia, that you can be experienced also in Camp Santiago arbitration rules anytime. Patrizia, the floor is yours.
Thank you very much. I would first like to express my gratitude to the Camp Santiago Center for inviting me and giving me today the opportunity to talk about the Vis Moot that you have perfectly introduced to the audience. When you would ask Professor Bergsten, the founder of the Moot, if he would have thought that the Moot develops to what it is now and to become such an important part of the arbitration community, he would say no. Yeah, he was certainly not having this expectation. He told me when he returned home from the first Moot, he told his wife after collapsing on a couch, at least it wasn't a failure. Yeah, Well, we know nowadays that the mood is much more. Yeah, it's certainly not a failure. And I'm glad to discuss today a little bit about the impact on the law, the practice, and the next generation the mood has taken. Since the idea was introduced, as you said, in 1992, and the first mood was organized, the mood has reached an enormous size in its 28th year now. And I will share with you the current numbers. We have 387 registered teams consisting of more than 2,400 registered students coming from 82 countries. There are more than 1,200 registered arbitrators with 98 nationalities. So together with the coaches, we count about 4,500 participants in the mood that all dedicate their time and efforts to the areas of international commercial arbitration and international sales law. Diversity is one of the biggest assets of the mood, and I'm not yet talking about gender or cultural diversity, but bringing together students coming from different legal systems and different traditions of legal education. Not only the typical civil or common law teams, but teams coming from mixed systems, partly rooted in Muslim law or customary law. And although there are significant differences in the legal systems and traditions of legal education, the mooting itself, the mooting concept helps to link all these differences, as it requires similar skills, although the methods might vary, but it is about resolving a problem, perform a legal analysis, assess the facts, prepare arguments, do the legal research, and plead the case. So the approach, how to get there, might be different, but the skills that are necessary are the same, and arbitration is a preferred method to resolve international commercial disputes, and actually perfectly fits into this mooting concept. Which impact has the Vis Moot on the law? Each year, the Vis Moot problem requires thousands of students to deal with important legal instruments, and not only with the CISG, but for example, with the UNITRA principles of international commercial contracts, then the New York Convention, ancestral model law. But regarding the CISG, this was the initial idea of the moot to promote the CISG and thereby to overcome the differences in the law governing contracts in different countries to facilitate international business transactions. Arbitration was at that time merely a side educational effect of the moot at the beginning. Yeah? This has changed. And the CISG is a good start to promote uniformity of law. However, the challenge is its uniform application in the interpretation of the provisions. The moot is thereby a valuable tool to serve this common purpose of uniform application. Each year, thousands of students are trained to achieve a good understanding of the CISG. But it's also a good testing ground for new ideas that can be attached to the problem. And the moot organizers collect the real case problems and ideas from practitioners, scholars, but also from institutions. One example we had in the moot problem once discussion, the problem existence of an unwritten hardship exemption under the CISG. And the next year, the CISG Advisory Council, which is a private academic initiative of renowned CISG experts, issued an opinion on the very same topic. So throughout the years, and I would even go so far to say because of the moot, the academic writing, opinions, and reported decisions on the CISG have considerably increased. Many of the authors are taking part in the Vis Moot at various levels. And each year, the Vis Moot problem applies different institutional arbitration rules, this year the Swiss rules. Many of the arbitral institutions whose rules are being used take the opportunity to test the application of certain provisions in their set of rules. procedural issues in the problem have become more and more specific over the years, touching on topics that are of general interest in the arbitration world. The Vis Moot has raised quite some attention last year at the beginning of the pandemic, when we conducted the first virtual Vis Moot. And as this was at the very beginning of the pandemic, the practitioners were not themselves very much familiar at the time with conducting remote hearings. However, it helped a lot the acceptance of remote hearings in the practice. We conducted at the time 500 or more than 500 remote hearings in 5 days. So that was quite a challenge. We had just 4 weeks to organize that when the COVID-19 pandemic arrived. So what I would like to say is that particular aspects allow an in-depth analysis of the current issues. And there is a vivid exchange, and we also see it at today's conference, on various aspects of the moot problem. They are discussed in conferences, in webinars, in the run-up to and during the Vis Moot week. Also, these specific issues dealt with in the moot problems find inclusions in publications, generating again a broad exploration of the topic and a good understanding on an international level. When the moot started, and then I'm talking now a bit the impact on the practice, in most of the law firms 28 years ago, arbitration was no specific area. It was not a practice area on its own. And also the university programs did not specifically offer courses on arbitration or on the CISG. Now this has become a regular part of the legal education, and there is a variety on educational offers and university programs worldwide available. I dare to say that this is due to the Vis Moot having spread the enthusiasm for international commercial arbitration across all regions in the world. And the Moot has generated thousands of students that obtain skills in advocating arbitration cases. Thanks to the character of the Vis Moot, which is the emulation of real legal practice to the widest extent possible, it vests the participating students with knowledge and skills they will benefit from over the course of their careers. Public speaking, research skills, drafting submissions, and strengthening the advocacy and communication skills. So the Vis Moot helps to educate the next generation of arbitration practitioners, but it also fosters the development of a standardized practice in the field of international arbitration. I would not go so far and would not or even opine that it creates standards. No, but it helps to understand what standards can be expected in arbitration, independent from where you come from. And this helps to foster international business. What is the impact on the next generation? What I can see now after being involved in the Vis Moot for nearly 20 years, the Vis Moot contributes to the next generation of arbitration practitioners significantly. Former mooties, as we call them, are part of arbitral institutions, partners and associates in law firms. Participation can kickstart their career. It's often an asset in hiring decisions due to so many valuable skills that you would not gain in a normal university education. In my arbitration team, I'm working with former mooties. All of them are former mooties, and there is a reason for that. It simply opens, the participation in the Moot opens the door for the first internship, associate positions in international practices. And the Vis Moot community that has developed, it functions as a valuable network for Vis participants, creating new platforms for various opportunities and have served to kick off new initiatives, be it, for example, below 40 organizations of arbitration groups, the Moot Alumni Association, Arbitral Women, and young practitioners become part of these individual groups. They meet people that serve as a valuable contact for future careers. But what I'm particularly proud of is the diverse environment the Moot offers. It's a role model of what a diverse arbitration community could and should look like. More than 40% of participating arbitrators and around 60% of participating students are female, with the number still increasing steadily. And I will leave it to say that the importance and impact of the Vis Moot cannot be limited to the event itself. I will also say, please enjoy the Vis Moot spirit. Everyone who participates knows exactly what I mean with that. And with this conclusion, I will leave it. And thank you very much for your attention and time.
I see. Thank you very much, Patrizia, for your words. They are so useful for us. And as everybody knows, or I don't think if everybody knows really, the fictitious case for this Vis Moot is always fictitiously handled by a real arbitration institution and each year sponsor who wish their arbitration rules to be used in the future edition of this Vis Moot are invited to submit an application to the Moot Association. This year, the rules applicable to the 28th Vis Moot are the Swiss Rules of International Arbitration of the Swiss Chambers Arbitration Institution. The Chambers of Commerce and Industry of Basel, Bern, Geneva, Lausanne, Lucerne, Lugano, Neuchâtel, and Zurich established the Swiss Chambers Arbitration Institution as a non-profit organization which offers means of dispute resolution based on the Swiss Rules of International Arbitration and the Swiss Rule of Mediation. To learn about the Swiss Chambers Arbitration Institutions, the Swiss rules in 2021, and how they are built in the future, today we are honored to have Dr. Xavier Favre-Bulle. Dr. Favre-Bulle is the president of the Court of the Swiss Chamber Arbitration Institution and partner and head of arbitration at Lenz, Staehelin at Switzerland leading law firm. He has more than 25 years of experience in dispute resolution, and he has been involved in more than 245 arbitrations. Xavier is member of the panel of arbitrators of, among others, ICC Switzerland, Singapore International Arbitration Center, and Hong Kong International Arbitration Center. Xavier, the floor is yours.
Thank you so much, Macarena. Apparently, you can hear me, and buenos dias a todos. Good morning, good afternoon, depending on where you are in the world. I'm very honored to be with you today. It's a great pleasure to have the feeling to be in Chile, yet remotely. But you see some sun here in Geneva, Switzerland as well. I started as the new president of the Court of SCAI, the Swiss Chambers Arbitration Institution, on the 1st of January this year, and I'm thrilled with what this year will bring for our institution, not only because the Swiss rules of international arbitration have been selected for the Vis Moot, also because of another major development. Last September, we announced that the Swiss Arbitration Association, ASA, ASA, and SCAI joined forces. We have a number of projects under that new umbrella, and among those, a revision of the Swiss rules. Before speaking about SCAI as it looks like today and our plans for the future, it may help provide some context. Switzerland has more than a century of experience of arbitration administered by chambers of commerce at the cantonal level. So we have common roots. When I see what you do at Camp Santiago, at some point, as you said, Macarena, 6 chambers of commerce, Basel, Bern, Geneva, Ticino, Vaud, Zurich, decided to unify their rules. They had rules on their own and they wanted to unify. Other chambers joined later. The concept of the drafters, ladies and gentlemen, was original. First, giving significant discretion to the arbitrators, which called for a form of ad hoc arbitration, but with the safety net of a solid body of rules. and the need for a supervising institution, but only with light administration, mainly a gatekeeping function. And all these combined led to the first Swiss rules of 2004, being based on the ancestral arbitration rules of 1976, adapted with original features, but deliberately kept to a minimum, as we said at the time. Do you know that the 12th Vis Moot 2004 was based on the Swiss rules? So that was our first venture with Mooties at the time. Now we are back for the second time. What were the main features of the rules at the outset that may be interesting for the participants? Consistent with the ancestral rules, flexibility for tailoring the procedure, certain powers of tribunals with respect to cost decisions, notification of the award, for example. So trust in arbitrators is a very important feature of the Swiss rules, that this is our original DNA. And among the novelties compared to the ancestral rules at the time, one may mention filing, possible at any one of the Swiss chambers, the expedited procedure, which has become famous, so 6 months for the proceedings for disputes up to 1 million Swiss francs, high degree of confidentiality, and a major innovation at the time regarding the participation of third parties. Article 4. Article 4.1 about consolidation of proceedings, decision by the chambers, even if the parties are not identical, taking into account all circumstances. This went quite far. The mechanism was original and it has worked well. Now 4.2 on joinder, participation of third parties, decision by the tribunal. What was contemplating was third-party intervention at the initiative of one of the parties to the arbitrations, joinder, or at the initiative of a third-party intervention. The tribunal shall decide on a joinder request after consulting with all parties, taking into account all circumstances it deems relevant and applicable according to Article 4.2. That was very innovative indeed at the time. Since the tribunal is the body which will ultimately decide on a joinder request, the applicable criteria are of paramount importance. What was probably unexpected at the time was what some commentators would start writing about Article 4.2, and quite relevant to Mooties this year. Some scholars indeed suggested that by agreeing to the Swiss rules, the parties are deemed to have given their consent to the intervention of third parties, such that any original party to the proceedings could request that the third person be joined without having to meet other requirements, in particular without the consent of the party to be joined, and a third person could request to participate without the consent of the original parties to the proceedings. Such views led to criticism and even concerns that the Swiss rules could be less chosen, less attractive, as potential users might fear that Article 4.2 could or would have far-reaching effects with broad jurisdiction of the tribunal in joinder situations without a need for particular consent. Now, I, speaking for myself, as a practitioner, nothing to do with the Vis Moot case, I have never shared this view. Article 4.2 should not be read, in my view, as a substitute for the consent of the initial parties to the arbitration or the third person in case a jurisdictional objection is raised. That objection must be decided in accordance with the lex arbitri, such as Article 186 of the Swiss Federal Private International Law Act, when the place of arbitration is in Switzerland. Of course, consent may be implied according to the theories which allow extending an arbitration agreement to a non-signatory in certain circumstances, but it is so according to the law applicable to a tribunal's jurisdiction, and not just because of Article 4.2 Swiss rules, in my humble view. The blurred notion of anticipatory consent under the Swiss rules would be too uncertain. It has no sufficient legal basis to resist challenges, according to my opinion. Now, the Swiss rules were amended in 2012, light revision, We did not adapt the Swiss rules to the new UNCITRAL rules 2010. That would have been a possibility. The Swiss rules had actually acquired their autonomy. They were no longer UNCITRAL dependent. As no major problems had been reported, the amendments were limited. The institution was renamed as the Swiss Chambers Arbitration Institution. So this is from 2012. SCAI, SCAI, a non-profit association separate from the Swiss Chambers, as Macarena, you said before. The model arbitration clause was amended accordingly. A true court, capital C, was created, replacing the former arbitration committee, so with enhanced powers, in particular for the review of the tribunal's decisions on costs. A very innovative emergency arbitration procedure was adopted. Probably you are aware of that. And what about our Article 4? Well, it was not substantially modified. Only some language improvement and clarifications as to who must be heard. Why? Because there was no real issue in practice. So the couple of joinder applications, just a couple of joinder applications, had not caused particular problems. As regards hearings, another topic of interest for Mooties, the 2012 version of the rules brought a refresh of the old-fashioned 2004 version, too influenced at the time by the UNCITRAL rules of 1976. So it was specified in 2012 in Article 25.4, the arbitral tribunal may direct that witnesses or expert witnesses may be examined through means that do not require their physical presence at the hearing, bracket, including by video conference, bracket. So not sure that that really supports the argument that the Swiss rules require an in-person hearing. But again, speaking for myself, where are we today? What can be said about the application of the Swiss rules in general is all good. Swiss rules arbitrations are often faster than under other rules due to the quick constitution of the tribunal, no need for terms of reference, no awards scrutiny, and so on and so forth. The administrative costs are low. We've had more than 1,300 cases since 2004. The average is around close to 100 per year and higher for some years. 90% of the cases are international. Domestic arbitration is very limited in our countries, mostly international. Around 70% of the parties are non-Swiss from more than 120 different countries. I'm now trying to compete with the figures we heard for the moot, but it's difficult. Around 40% of the cases are subject to the expedited procedure, hence the speed. Less than 12 months on average for all kinds of procedures. And among the arbitrators the institution appointed last year, 71% of female arbitrators. So we are proud to be quite high in terms of gender diversity. The court is composed of 26 members, 10 female lawyers. Some members are outside Switzerland and they are obviously experienced in arbitration. The Secretariat assists the court in administering arbitration proceedings from 3 offices in Geneva, Zurich, and Lugano, covering French, German, and Italian, in addition to English, which is the feature of Switzerland, and close to 70% of the cases are in English. The Swiss rules are supplemented by the internal rules of the courts and guidelines for arbitrators. All these documents are available on the website. With my colleagues, our role is to build the future. And as I mentioned at the beginning, 2021, this year will be a key moment in the history of our institution. There will be soon a new SCAI, in the form of a company limited by shares with EISA and the main Swiss chambers as shareholders. Corporate and structural reforms are expected, most likely with a new name, but this is still confidential, I'm afraid. Please be patient, a lot is to come. And our Swiss rules. Well, there is a need to amend them due to some changes arising from the new structure at SCAI's level. Pragmatically, this is a good opportunity to assess the rest of the provisions. And last summer, we started a review exercise with dedicated committees. It was intended to be, again, a light revision, but what I have on my desk shows significant amendments. Well, a number of amendments. This is often to simplify, improve the structure, form, and clarity. The substance itself is not necessarily changed, but nevertheless, you will see in due course that this is an interesting revision. At this point, our draft of the revised rules is confidential. The release will be after the Vis Moot finals, so no concern that the revised rules could influence this year's case be reissued. What I can emphasize are the challenges when revising rules in 2021. Examples of what is worthwhile considering, and really as open questions and not suggesting that this will be adopted or not. The role and powers of the courts and the Secretariat respectively. Should there be more involvement, for example, for the management of the advances on costs and other tasks that were intentionally left to tribunals at the beginning, as you now understand, consistent with the approach of light administration coming from the ancestral rules. The possibility of electronic filing, the electronic signature of the award, but however, with the difficulties arising from the applicable law, the New York Convention, very hot topic. The 1 million Swiss franc threshold for an expedited procedure, should we go higher? Third-party funding, early determination, summary dismissal, cybersecurity, data protection, and so on and so forth. Very interesting questions, but so hard to decide what to do. I had a session again this morning with some colleagues, and this is very difficult to say we should do that, we should not do that, we should copy the other, we should be autonomous. Very difficult. Now, regarding gender and intervention issues, I like, speaking for myself again, I like the approach of the current Article 4.2 and also 4.1 on consolidation, leaving wide discretion, allowing to take into account the particular circumstances of each case without too stringent rules on the procedural aspect, such as until an application for joinder can be validly be made. I mean, interestingly enough, the ICC, which started with narrow rules on joinder in 2012, has just relaxed them in its latest 2021 rules to open the door to joinders after the tribunal's constitution. As to virtual hearings, my opinion is that arbitration rules should not encroach on, first, the parties' agreements, as this is what primarily matters, and second, the powers of arbitrators to decide on the best format to hold a hearing. The rules should be sufficiently clear that they do not impose anything. What is paradoxical to me is that most arbitration rules are almost silent on procedure in general, which is usually an area left to the parties and the tribunal to tailor in so-called specific procedural rules adopted before the arbitration proceeds on the merits, as the procedural aspects are better organized on a case-by-case basis. Now, with COVID-19, most institutions suddenly saw the need to interfere and propose rules and protocols of all sorts to regulate the fields, which, in my view, remains in the hands of others, the parties and arbitrators. And we have heard witnesses by video for a long time. This is not new. Yet, Zoom platforms, etc., allow the hearing to be entirely online and remote, but this does not change the face of the world. My conclusion is, let's be relaxed about the format of a hearing. It is certainly better to hold a hearing via screens than to push back endlessly in the hope to be able to hold a physical hearing one day. My tribunals have wasted months last year with such rescheduling. I hope I have convinced you that the perspectives are promising for our institution and rules. The current to be revised. It's highly stimulating and rewarding to work on projects for increased diversity, developing certain industry sectors, improving our presence in certain regions, such as in Latin America, handling complex arbitrations efficiently, also in new fields. I will stop here. I thank again the organizer, Santiago, my fellow colleagues today for the kind invitation and certainly a challenging discussion. Most importantly, I wish to say good luck to all Mooties. Take care, be safe, and enjoy this year's case based on the Swiss rules. Thank you.
Thank you very much, Xavier. And just to ask you, which was the biggest challenge for your institution during the change of rules for 2021? Because we are in the same process, you know, and we don't have to forget that COVID-19 pandemic has had devastating effects on all over the world, and it has also been a catalyst for change in this moment of opportunity, many rules. So just to ask you, which has been the biggest challenge during this process for you?
I have to say, apart from COVID-19, the time is unfortunate because we, as I explained, we must amend the rules because of the new structure coming. And many other institutions have just amended their rules or will amend their rules very soon. So we are probably not at the ideal time because we are almost all competing together with new rules. And that was not our goal in the first place, to come with the best rules. The goal was to adapt to our new structure. Now, the challenges really is in those circumstances, in that situation, is whether we should copy the others, because the ICC has done that, we should do the same, the RCLA, we should do the same, or whether we should stick to what the rules were in 2004, antitrust influence, flexibility, autonomy of the tribunals, slightly adapted in 2012, keep that track. And this is what I recommend. So we are fine-tuning, but we will not come with a revolution. We will not say, now, because of the others, because of COVID, we'll have many new items. And in practice, last year, we had to adapt with electronic filings, with things like that we will simply put into the rules in a more formal way, but I think we have managed. So probably no real big challenge apart from the policy, the strategy, whether being autonomous or influenced by the others.
Okay, thank you. No, thank you very much. I think there is a question for Xavier, Claudio. Can you tell us the question, please?
Yes, Macarena. And there's a question from Vicente Caputo. Vicente is a student from the University of Chile. And he asks, in your opinion, what could be the requirements of the Swiss rules for the inclusion of a union to be considered valid? Of a joinder, he corrects.
Sorry, could you repeat that?
Yes. In your opinion, what will be the requirements of the Swiss rules for the inclusion of a joinder to be considered valid?
That might be a question influenced by the Vis Moot case. Patricia, no, frankly, I said a few words in my presentation regarding Article 4. I don't know, Patricia, if you want to add anything in this respect.
I will not dare to do it.
Yeah, no, what I would like to say is this. The current Article 4.2 has this feature that it deals with the tribunal. And what is actually challenging for an institution is more the previous stage at the level of the institution, how you constitute a tribunal when there is a joinder situation, which is actually not addressed in the Vis Moot because we decided to have a tribunal appointed by the institution in the Vis Moot case. So when it is before the tribunal, and I will not now deal with the Vis Moot case as such, but I will just present the two main situations. If the question before the tribunal is whether an additional party, non-signatory, should be joined to the proceedings because it is alleged to be a party to the arbitration agreement, this is a very classical question of the extension of the arbitration agreement, and this has, in my view, nothing to do with the rules, whatever the rules are. This is depending on the law applicable to this question of the extension. Now, the interesting situation addressed in the Vis Moot case is when there are two contracts with a new party joined and possibly with a claimant not happy to have this new party for two different contracts. And here, what is interesting for a tribunal, the test is more the compatibility of the arbitration agreements and whether we would impose an agreement that all parties have expressly or impliedly agreed that those cases could be dealt with together, or whether the tribunal has more discretion and to take into account circumstances like confidentiality, efficiency of the proceedings, and there is no answer in the rules. So I will not say that there are requirements, because this is precisely some flexibility which should be left to the tribunal. But again, there are questions which are really of jurisdiction, whether there is a party which can be joined within the scope of an arbitration agreement. And when there are different contracts, when we are in a multi-contract situation, it may be more about the compatibility of those arbitration agreements and the efficiency of having one case heard at once instead of having two different cases. And not something easy to be decided by a tribunal, frankly.
Thank you very much, Javier. We know you have to leave us, but let me say thank you again for joining us today in this very important event for CAM Santiago, and I think all the students that are participating in our next Vis Promote. So thank you very much. And now we continue.
Again, I'm very happy. I'm sorry to have to leave, but I have now also the real world, which is a case management hearing in a case. But I wish you all the best, and sorry for leaving.
Thank you very much, Javier. Well, let's continue. And you know that on September 4, 2020, co-editors Giacomo Rojas Elgueta, James Hoskin, and Yasmin Lalou, in collaboration with International Council for Commercial Arbitration, formally launched the research project, Does a Right to a Physical Hearing Exist in International Arbitration? The project arises from the need for reliable jurisdiction-specific information on the core legal question posed by the increased use of remote arbitral hearings due to the COVID-19 pandemic. With the help of national reporters from across the globe, the co-editors are compiling a comparative survey covering from 86 New York Convention jurisdictions, and at this time they have released 26 reports that reveal many common trends and convergence in response to the core question of the survey. To learn about this project, we are honored to have Dr. Giacomo Rojas Elgueta. Dr. Rojas Elgueta is a founding partner at DR Arbitration and Litigation, an Italian boutique law firm specialized in arbitration and litigation service, and as associate professor of private law at Roma III University, where he teaches private law and economic analysis of law. He also coordinates the Certificate in International Commercial and Investment Arbitration, Theory and Practice. Giacomo has acted as sole arbitrator and co-arbitrator in various arbitration proceedings, both ad hoc and under the rules of many international centers as ICC, CAM of Milano, and Italy and Switzerland international arbitration centers. Giacomo, the floor is yours.
Thank you. Thank you very much. I'm grateful to Camp Santiago for this very kind invitation, to Herman Chadwick, its president, and Macarena, Letelier, its executive director. I'm very happy to be with you today, particularly because you are in Santiago. It's the city where my father was born and where I used to spend my Christmas vacations when I was a kid. So hopefully next time it will be in person. So as introduced by Macarena, my topic is whether a right to a physical hearing exists or not in international arbitration. And to address this topic, I will present a few slides. So I will share my screen. Please let me know whether you can see it.
Perfect, Giacomo. We can see it. There's no problem.
Great.
Go ahead.
Great. So I'm trying to, okay. So before COVID-19, of course, the default approach was to hold this sort of super spreader events called arbitration hearings, where we used to be all together in one physical room, but we already were accustomed to remote procedural meetings, such as the case management conference, the one that Xavier is about to start. So that was the world before COVID-19. After COVID-19, of course, there was a major shift toward remote hearings, and here I am referring particularly to fully remote hearings, where all participants are basically in a different location and there is no one main physical venue. And this shift was also accompanied by changes in rules of the main arbitral institution. And here in my slide, you can read the LCIA new rule in Article 19.2, where you can read a hearing may take place in person or virtually, and the same for the new ICC rules, Article 26.1. So first of all, I think it is important a terminology clarification. Why remote instead of virtual, instead of online? We decided in our project to use the word remote because virtual is sometimes used to indicate something that does not exist in reality. For example, a virtual landscape in a video game is something that does not exist. While remote hearings are actually made by humans, they are very real, even though held remotely. So we prefer to use the word remote instead of virtual, not to create any confusion with artificial intelligence and so on and so forth. And so also we wanted to make clear that we do not deal with online arbitration, which is a different animal. And on the other hand, we use the word physical in our project instead of in person, because actually the previous ICC rule used the word in person without meaning, basically, it was not clear whether it was an equivalent of or physical or not. There was a lot of discussion in the first months after the COVID-19 outbreak. And therefore, through the use of the word physical, we are sure that everyone understands the meaning. So after the COVID-19 outbreak, of course, we saw the major shift toward the remote hearings and new legal questions actually arising. So the main question is whether arbitrators can order a remote hearing even when one of the party objects. This is the main scenario that most arbitrators were facing after, let's say, March 2020. And the first answers that I was hearing in several webinars around the world was, it depends. It depends on what the law of the seat says, what are the arbitration rules chosen by the parties. So basically there was not a satisfactory answer, because it was always, it depends. And this was the trigger behind our project. The idea that in order to have an answer to these questions, you need to have a jurisdiction-specific answer. You need to look for answers at each single jurisdiction that is the seat of the arbitration. So as Macarena said before, we launched this project with ICA, so I'm not repeating the main timeline of our project. I just wanted to stress that we received more than 150 expressions of interest, and we are going to cover a total of 86 New York Convention jurisdiction, and in a few days we will release a second batch of national reports that will cover many more countries. So let's look now at the preliminary results that we collected from the jurisdictions and the reports that you can find in a dedicated ICA web page online. So let's look at the very first question that we were asking to our national reporters. Does the lex arbitri of your jurisdiction expressly provide for a right to a physical hearing in arbitration? So none, zero jurisdictions answer yes to this question. So apparently there is no country in the world where the lex arbitri expressly provide for the right to a physical hearing. So we need to move to the second question, which is, if not, can a right to a physical hearing in arbitration be inferred or excluded by way of interpretation of other procedural rules of your jurisdiction's lex arbitri? And with regard to this second question is when things start becoming more interesting. I would say that the majority of the jurisdictions are answering no also to this second question, and they are excluding the right to a physical hearing by stressing three main indexes. The first index is that the lex arbitri normally provides for a broad procedural discretion to the arbitrators, and this procedural discretion is interpreted to include the possibility for the arbitral tribunal to order a remote hearing, notwithstanding one party objecting to the remote hearing. The second index that has been stressed by several national reporters is the fact that in that country, in that jurisdiction, arbitration based on documents only is allowed. So the argument is, if documents only arbitration is allowed, even more so, an arbitration with a remote hearing should be allowed, because of course documents only is less than remote hearings. A third argument that has been stressed by several national reporters shifts from the lex arbitri to institutional rules. For example, the Santiago rules. And here the argument is, well, the lex arbitri is silent on the issue, but the main institutional rules in our jurisdiction allow remote hearings. And it would be paradoxical that the main arbitral institution allows something that is forbidden by the lex arbitri. So this is not a legal argument per se in itself, but it is a persuasive argument. Again, it would be sort of paradoxical, for example, that the Milan Chamber of Arbitration allows remote hearings and Italian procedural law does not allow remote hearings. There would be a sort of paradox. Of course, the possibility of ordering remote hearings is not unlimited. In all the countries we have surveyed, reporters are stressing that this procedural discretion is limited by the due process, the right for the parties to be heard, equality of the parties. So this procedural discretion is not unchecked, is not unlimited, and must be read within these boundaries. Also, it must be stressed that to question number 2, we have received questions that go in the opposite direction, meaning that in some jurisdiction, a right to a physical hearing can be inferred. So the opposite of what we have found in most of the jurisdictions. This is the case, for example, in Vietnam, and you can read the national report of Vietnam, which is already uploaded in the ICCA website, but it's also the case for countries such as Ecuador, Benin, Norway, Sweden, Tunisia, Zimbabwe. So a significant number of jurisdictions find that there is a right to a physical hearing if the arbitration is seated in that country that can be inferred by the lex arbitri. The most interesting jurisdictions are the ones that adopt the UNCITRAL model law. As you probably know, the UNCITRAL model law provides at Article 24.1, and Chile is one of the model law countries for international arbitration. So Chile adopted Article 24, which, as you can read in this slide, provides for a right to a hearing. It is the very last paragraph of this provision, but it does not specify whether the right to an oral hearing translates into a right to a physical hearing. And here we have different jurisdictions reporting different interpretation of the word oral. What does oral means? Of course, orality in general means a sort of immediacy between the counsel, the parties, and the arbitrator, the possibility of exchanging views and arguments in real time. And per se does not mean physical, does not mean that this should happen in the same physical place. But having said that, we have countries like Chile, and the report of Chile is not yet published. I can anticipate that has been written by Andres Hanna, that probably all of you know very well. And Andres Hanna is clearly saying, well, right to oral hearing does not translate in the right to a physical hearing, and therefore oral should not be interpreted in Chile as physical. But there are other jurisdictions such as Sweden. Sweden is a very important seat for international arbitration because of the Stockholm Chamber of Arbitration, saying the very opposite. It is a model law country. They also imported Article 24, but they are saying that in Sweden, the expression oral hearing means physical hearing. And this conclusion is reached because of two main arguments. Because when a witness can be heard remotely, this is expressly provided. And so the argument goes, this means that the other parts of the hearing are cannot be held remotely, otherwise it would be expressly provided so. And also the fact that in the Swedish lex arbitri, the fact that procedural meetings can be held remotely is again expressly specified. So you see the very same rule, Article 24 of the model law, interpreted in two opposite ways in Chile and in Sweden. Then you have the case of Hungary, when the word oral has been stricken out from the legal system altogether just to avoid confusion, to make sure that oral does not mean physical. In Hungary, they got rid of the word oral in the Code of Civil Procedure. Then you have the case of Zimbabwe, where oral is interpreted as physical because of a very practical reason, because there is not a widespread internet connection, telecommunication network in the country, and therefore it would be impossible to hold systematically remote hearings. And this is the reason why oral, in the meaning of Article 24.1 of the model law, is interpreted as physical. And then you have other jurisdictions as Denmark and Bahrain, where the reporters say, well, it is too early to say. It is an unsettled issue. We do not know whether oral hearings mean physical or not. So what is the main takeaway? And I will stop here because I think I ran out of time. So what is the main takeaway of what I illustrated to you? That we really have to look at the seat of the arbitration, at the lex arbitri. There is no transnational answer to the question. We cannot say that in international arbitration there is or there is not a right to a physical hearing. It is really a question that imposes, in the first place, the arbitrators to look at the lex arbitri in the place of, which means the law applying at the seat of the arbitration. I encourage all the mooties to go online to download the reports that are already there, because you can find a lot of information. And good luck with your Vis next week. Thank you very much.
Thank you very much, Giacomo. Giacomo, grazie mille per le tue eccellenti presentazioni. Siamo molto felici per la tua partecipazione alla nostra conferenza. Sappiamo che è ora di pranzo in Italia, ma ancora grazie mille per essere con noi oggi. Bello sapere che tuo padre erano cileno. Nella mia famiglia i miei bisnonni erano italiani, quindi l'italiano è una delle lingue che mi piacerebbe parlare meglio. Ci augurio che in futuro voi possa viaggiare qui nel nostro paese. Molto grazie per voi tu con noi. Muchas gracias. Thank you very much, Giacomo, for your participation. We're so happy to have you here today. So if we have some questions, I don't know, Claudio, can you help me with that?
Before the question, we're going with the last presentation, Laura, if that's okay with you.
Ah, perfect, right. So you can go ahead with it.
Thank you very much, Laura. The contract of sales is the backbone of international trade in all countries, irrespective of their legal tradition or level of economic development. The purpose of the UN Convention on Contracts for the international sale of goods is to provide a modern, uniform, and fair regime for contracts for international sales of goods. Thus, the CISG contributes significantly to introducing certainty in commercial exchanges and decreasing transaction costs. The Article 42 CISG refers to third-party claims based on a patent or other intellectual property. This article provides us that the seller must deliver goods which are free from any right or claim of a third party based on industrial property or other intellectual property, of which at the time of the conclusion of the contract the seller knew or could not have been unaware. To learn about the seller's liability for infringing goods under Article 42 CISG, we're honored to have Dr. David Tebel. Dr. Tebel is an associate partner at Rothorn Legal and a newly founded German-Swiss boutique law firm. Dr. Tebel advises and represents clients in complex proceedings before arbitral tribunals and state courts, both domestic and international. He has broad experience with industrial product liability cases, particularly governed by international sales law, large-scale infrastructure projects, and corporate disputes. David has acted in proceedings governed by the DIS, ICC, and ICSID rules. David also teaches as a founder and director of the Moot Academy, and before that as lecturer at the Swiss International Law School and at the University of Basel International Sales Law. He has recently appointed by the CISG Advisory Council as reporter for the future CISG opinion about the seller's liability for infringing goods under Article 42 CISG. David, the floor is yours.
Thank you very much for those kind introductory words and for inviting me. It's my pleasure to be here at the second CAMP conference and to talk a bit about Article 42. And indeed, it is interesting that there again seems to be some kind of a coincidence, I will not say causation, between the topic of this year's Moot Court and future CISG Advisory Council opinions. I'm not going to disclose what would have been the cause of what here, but it is my pleasure to discuss with you today the issue of Article 42 of the CISG. And as also foreshadowed, I will not go into the details of this year's moot problem. I would rather provide participants and also interested parties with the context, with the framework of how this provision actually operates. And I think that this context and this framework informs many of the questions that are being discussed with regard to this issue that is pertinent in this year's moot problem. And actually, it is also an economically important provision, and it gains more and more traction. One of the indicative numbers for the economic importance of Article 42 as a provision, and we've already heard what it's about, is border seizures of intellectual property in infringing goods. And just to give you an example of numbers in Chile, actually, between 2017 and 2018, the quantity of the seized goods based on intellectual property violations doubled, or rather was an increase by 50%, and the value was increased by twofold. So we see that it's rising continuously, the economic importance of violations of intellectual property rights in international transfer of goods and also international sales of goods, obviously. So if we are not going to talk about the question of this year's moot problem, what are we talking about? Well, we will focus on three aspects of Article 42. I mean, we have limited time and there are many issues to discuss, but these are the 3 points that I would like to address today. I would like to start out with the purpose of the provision, which is of fundamental importance to understand and answer the many questions relevant to this provision. Then we will briefly have a look at the notion of encumbrance. And then we finished off with one of the most interesting issues of this provision, which is the role that knowledge plays in the application and interpretation of Article 42. So let's start with the purpose. And to understand the purpose of Article 42, we have to first take a step back and look at the bigger picture here. And obviously, all of you are aware that under sales law generally, in the CISG and in almost all domestic sales laws, there are generally 2 categories when it comes to defects, 2 buckets, so to speak. On the left-hand side here, you can see the non-conformity bucket. I don't have to explain what that is. It's defects of the goods relating to the physical features. So that is clear. On the right-hand side, you see the third-party rights bucket, and that is not as relevant in practice. So it is important to remind ourselves that the decisive criterion with regard to third-party rights is that they generally derive from the history of the goods. So they have to do with something that happened to the goods or that happened before the goods were sold. And with that in mind, let's look at the interest of the parties, and we started with the buyer's interest in a general sales contract. Again, I'm aware that this is not news to you, but it is important to remind ourselves what the general framework within which Article 42 resides in is actually about. And it is about protecting the buyer's interest in using the goods. This is not a given with regard to sales law in general. It's not the case with regard to each and every domestic sales law, and also from a historic perspective, it's not a given. Yet under the CISG, this is the aim of the liability regime of the seller, to enable the buyer to make unimpeded and full use of the goods. And this is the reason why we have the provisions of Article 35 with regard to non-conformity of the goods, the left bucket, if you remember, and Article 41 with regard to third-party rights. And Article 41 actually is quite a broad regime for the seller's liability for third-party rights in general. And it has in mind third-party property rights, like the right of title. And we see here, we not have to go into the language in much detail, but it doesn't have very many qualifications or limitations. It just basically holds the seller liable if there are any third-party rights encumbering the goods. But in the second sentence, we see a notable exception, which all of you are aware of. It says that if the encumbrance is based on intellectual property, then we have to look into another provision, then we have to look into Article 42. So we take with us from that Article 41 is the rule, which is quite strict with regard to the seller's liability, and Article 42 provides an exception from that rule. That is again important to keep in mind when looking at Article 42 in a few seconds. But before we go there, we have to understand what is it that these provisions actually deal with? What is intellectual property? As somebody trained in sales law, and I think most of us dealing with this Vis Moot problem also have rather focused on sales than IP law. It helps to remind ourselves what are the decisive traits of intellectual property right. And intellectual property as a starting point is the protection of a commercial or intellectual accomplishment by attributing it in form of a right to a certain person, the so-called holder of this right. That is the starting point, and it's helpful in distinguishing Article 41 from Article 42. And there are certain decisive traits that these kinds of rights, intellectual property rights, have, which help us inform which provision to apply. And the most important of these traits is that intellectual property rights are territorial in nature. This so-called principle of territoriality means that intellectual property rights only apply in a certain territory where they are registered, where they came into existence. To give you a simple example, if you are the holder of a patent, you invented something very interesting, very fancy, you are monetizing it, you're protecting your intellectual property by registering it as a patent, you have to do so as a general rule in each and every single jurisdiction you want to have your intellectual property right protected. And that is very much opposed to the universal application of property rights. If you hold title in a certain good, then this title, as a general rule, is recognized globally. There is no need to formally introduce, formally recreate, or have accepted or whatsoever your title in a certain good in a certain jurisdiction. So this is an important distinction between property rights, again, which are dealt with by Article 41, and intellectual property rights, which are dealt with by Article 42. On the bottom here, you see two more features of intellectual property rights, which are relevant for our analysis. On the left-hand side, you see that intellectual property rights are dependent on the physical features of the goods. Well, we just heard that property rights are independent of the physical features of the goods. This is not true with regard to intellectual property rights. If you have a good that violates, let's say, a trademark because a certain label on the good, you can just remove the label and thereby change the physical features of the goods to do away with the infringement problem. So amending the physical features of the goods is relevant when it comes to intellectual property rights. And on the right-hand side, you see another interesting criterion. You see that intellectual property rights apply to all goods of the kinds. Again, that's a difference with regard to compared to property rights. Property rights know the principle of specificity. So you have to make sure that a certain property right is directed and directly connected to a specific thing. This is not the case with regard to intellectual property rights. Intellectual property rights per se encompass each and every good that falls within the scope of the described intellectual accomplishment. And all these factors taken together show us that there are significant differences from the perspective of international sales law. I mean, if you put yourself in the shoes of a seller, this makes it rather complicated. All these points make it rather complicated for you to assess your liability. And we will see about that in a minute. Now, having learned and now knowing what intellectual property rights are actually about and going back to the two buckets, Question is where to put them, where to put intellectual property rights. And if we, before looking at the CISG, because all of you know what happens under the CISG, but before we go there, if you look comparatively into domestic legal systems, we see actually examples for both. We see, for example, Swiss law, where intellectual property right violations or encumbrances of the goods with intellectual property rights are treated as so-called legal nonconformities and are governed by the regime of nonconformities. And we also see, and that is the majority of jurisdictions, jurisdictions in which encumbrances of the goods with intellectual property rights are treated as regular third-party rights, and there's just the general regime for third-party rights applied. But we also know that there is a third category of jurisdictions which have a third bucket, put squarely falling in the middle between the other two buckets, specifically for third-party rights based on intellectual property. A prominent example for this third category of jurisdictions is the Uniform Commercial Code in the United States of America. There is a so-called warranty against infringement, which deals with exactly that kind of situation. And obviously, Article 42 is also such a provision, and the CISG also has these three buckets. This picture, this image of the three buckets with Article 42 bucket falling in the middle between Article 35 and Article 41 is important again when interpreting the various requirements of Article 42 in order to remember that it's somewhere between the seller's liability for third-party rights in general and the seller's liability for non-conformities of the goods. This is now finally the language of Article 42. I'm aware that it's quite long and that's very small print, so I took the liberty of summarizing the important parts for you here. The first part of the provision deals with the seller's knowledge, and this is exactly the aspect we will have a closer look on in a second. All of you know that the seller is only liable for intellectual property rights which it knew of or could not have been unaware of at the time of conclusion of the contract. Then in the middle part, we have a so-called territorial limitation, which mirrors the territorial principle of intellectual property rights, and which holds the seller liable for intellectual property right violations only in certain states, in the state of use or in the buyer state. And in the end, we have additional limitations of the seller's liability based on things that happen in the buyer's sphere. A, the buyer's knowledge of the encumbrance, and B, the goods compliance with the specifications of the buyer causing the intellectual property infringement. If we look at these three main aspects, it becomes clear quite quickly that the purpose of Article 42 as compared to the rule of Article 41 is by exception limiting the seller's liability. And it does so, the provision does so in order to enable the seller to allow it to assess its liability risk at the time of contract conclusion in order to make an informed decision whether or not to enter into the transaction with the buyer. Coming now to the notion of encumbrance, all of you know that Articles 41 and 42, for what it's worth, apply with regard to rights and claims. The notion of right is pretty simple, pretty clear. It's an existing legal position with regard to the delivered thing. The notion of claim is broader. It also is fulfilled if the third party only purports to have a certain legal position, regardless of whether this legal position actually is given or not. And the CISG's decision to hold the seller liable also in case of mere claims is actually broadening the scope of the seller's liability quite significantly, also compared again to certain domestic jurisdictions. The reason why that this has been done in the CISG has aptly been described by Professor John Honnold in the following way: that the buyer is not purchasing a lawsuit. This is not what the CISG intends, and this is based on a typical information asymmetry between the buyer and the seller. We've seen that third-party rights, and this goes for property as well as intellectual property rights, are mostly based on the sphere of the seller. Something happened with the goods before, or something happened with regard to the goods in the sense of intellectual property rights being created, which encompasses the goods. This is much closer to the seller, which might be itself the manufacturer, or who might at least be closer to the manufacturer. So, and this means due to this information proximity of the seller, it is much easier for the seller to assess the veracity of a claim and to fend it off if need be. This is why the CISG, as a general rule, allocates the liability also for claims to the seller. And this also is true for you, obviously unfounded or frivolous claims. At least that is the majority view in literature and in case law. And it makes sense because this information asymmetry that we've just discussed also applies with regard to frivolous and unfounded claims, obviously unfounded claims even. And what is more, it is very difficult, not to say impossible, to draw a clear line between obviously unfounded claims and just unfounded claims. And just to add one note on this in this regard, in order for a claim to trigger the seller's liability, it is not required that this claim is raised in any specific form. It is purely completely sufficient if the third party alleges that it holds a certain right in what form soever. This takes us now to our final topic for today. It's the knowledge requirement. As you are aware, knowledge is relevant in Article 42 in two instances. It is relevant with regard to triggering the seller's liability in subsection 1, and it is relevant with regard to exempting the seller from liability based on the buyer's knowledge in subsection 2, litera A. And you can see here that the language used in both regards is identical: knew or could not have been unaware. So what does that mean? First, as a starting point, it is important to note that this requirement has to be interpreted autonomously. It is not permissible to default back to any notions of fault that people bring with them from their respective domestic systems. It is sufficient that the respective party knows about the existence of the right or claim. It is not sufficient that any detailed knowledge as regard to the classification as intellectual property right or not, and these things are known to the relevant party. And what is important to understand is that neither of these provisions, in particular not Article 42, requires a legal evaluation of the relevant claim or right. So it's not necessary that the seller has a view on whether or not the invoked intellectual property right is actually infringed. It's perfectly sufficient that the party knows about it. And with regard to claim or right, we have to understand that it is sufficient that the seller knows about the claim in order to trigger its knowledge of the right. So that means that knowledge of the right, knowledge of the claim includes knowledge of the right that this claim is based on. But this does not work the other way around. If the seller knows about a certain right, which might or might not be infringed, this does not say that the seller also knew at the relevant time about a claim which might be raised later on with regard to that right, if that claim is relevant to assess the seller's liability. And as a final point, we will briefly touch upon the question of constructive knowledge. Could not have been unaware, as it is phrased in the relevant sections of the provision. And here the central question is whether or not the parties can be expected to actively investigate for intellectual property rights. And it is generally held that with regard to the seller can be expected, and the majority view is that with regard to the buyer, it rather cannot be expected to actively investigate for intellectual property rights. Starting out with the seller, given that the majority view is the seller is expected to investigate, the question is how far, how much, how intensive does that investigation have to go? And there are a number of criteria, a number of factors which are relevant to determine the scope of the investigation on a case-by-case basis. And on the one hand, we have the objective accessibility of the respective IP rights. Is it registered? Is it published? Factors like this. And on the other hand, we have subjective factors regarding the seller or the buyer, if need be. And here we have factors like how sophisticated is the buyer or the seller, how strong is its presence in the market, in the relevant, how close is the seller to the respective intellectual property right. And I've already foreshadowed it. The central question then is, does the same standard apply for the buyer? I have told you that the majority view says no. Personally, I have a different view, and my strongest argument obviously is the wording of the provision, because it applies the same wording with regard to the seller and the buyer. Now, does it mean that we always have the same result, which would mean that the liability which is created by subsection 1 of the provision is always cancelled out by subsection 2? Obviously not. But it is important to understand that we have the same legal standard, and the difference is only a difference of fact, not a difference of law. Because the factors that we just discussed with regard to the scope of these investigations, they are very much different with regard to the seller and the buyer in the majority of the cases. So here lies the crux, here lies the difference. What should you take away from this? Article 42 is a prime example for balancing of interest of the parties involved. On the one hand, we have the buyer's interest in using the goods. On the other hand, we have the interest of the seller to be able to assess its liability risks. And these interests, these underlying interests, provide you with the knobs and dials to manipulate to reach the desired outcome with regard to basically any issue that this provision poses to you. And they help you to answer difficult questions also in the competition in this year's moot court. With that, I thank you for the invitation again, and wish all the teams much success in this year's moot court.
Thank you very much, David, and to all our guests for your magnificent presentations. Before we open the floor to the question of the attendees, do the speakers have any question or comment on your fellows' presentations? Giacomo?
Claudio, thank you for asking. No, just.
Grazie mille, Giacomo.
I would just say that I like the presentations very much and found them highly enlightening and very interesting.
Thank you, David, and thank you, Giacomo. Thank you, Patrizia, also. Now we're going to the questions. The first one is from Javiera Cisterna. Javiera asks, good morning. I have a question for Professor Giacomo Rojas. Do you think that the COVID-19 pandemic will set a new way of thinking about the practice of arbitration, or the intention of the arbitration community will be returned to normality? Thank you.
Thank you for the question. So I think there is, on the one hand, we are all waiting to go back to some sort of normality, because one of the beautiful part of international arbitration is also the idea of traveling, of meeting people from all around the world. There is a sort of glamour in international arbitration that we are missing very much nowadays. And also many clients are not fully satisfied with the remote hearings and are also eager to go back to normal. But on the other hand, I believe that to a certain extent, COVID-19 will change international arbitration practice for good. I think it would be sort of inconceivable to travel from all around the world for a one-day hearing after we are now all aware that those costs can be easily saved. And so it really will depend on the situation. And if people are traveling from few locations for something that is very relevant, I think there will be a preference for physical hearings. On the other hand, where the costs do not justify the effort, remote hearings will stay as a good alternative, not the the prime luxury choice, but the subprime good enough alternative? And I think clients will get used to choose between two different products, the luxury one and the subprime one, which sometimes makes sense to be chosen. So there will be changes, and we are all very curious to know what things will settle in the future.
Molte grazie, Giacomo. Now we have a question to Mrs. Netal. Gipsa Castillo asked the following, and regarding also the remote hearings. Which are the minimum requirements for a remote hearing to guarantee the procedural rights of the parties, taking into account the Vienna Protocol?
Well, we've actually heard it today, also according to the Vienna Protocol that provides guidance, and that was drafted shortly after last year's Moot hearings and published by VIAC, the Vienna International Arbitral Center. You would look into the Lex Arbitri, and I think since last year we have already some decisions, Supreme Court decisions dealing with virtual hearings, and in particular if they can be conducted against the will of one of the parties. Austria has one, and Switzerland dealt at least in respect to court litigations with remote hearings. Having said this, I think there is no other yes or no answer to that. Yeah, I mean, you look whether there is any mandatory law telling you something that would exclude the possibility of remote hearings, and of course there should not be any party agreement stating something otherwise. Beside that, you have to look at the specific circumstances of each case, and there are heavy document loaded cases where I'm not sure if it's really so easy to conduct oral hearings in, for example, big construction cases exclusively as a remote hearing. However, there are many cases where this is appropriate, but you have to maintain fair treatment of the parties. You have to comply with the right to be heard. And then you have really to look specifically at the circumstances. Are there any travel restrictions? Are the parties able to adjust to the technical means and requirements, or would that lead to a significant imbalance? It's not so an easy decision, but I think the technical means allow a lot nowadays and have improved substantially. Just in the last couple of means, there are so many new providers, platform providers for remote hearings that we haven't known 12 months ago. Yeah, and I think there is a lot possible that was not possible a year ago. So I would say there is no yes or no. It's still for arbitrators a hard decision if one of the parties is not willing to participate in a remote hearing. But I would say it's easier for the arbitrator to consider this possibility now if there is no agreement.
Thank you, Patricia. Now moving a little back to the CISG, I have a question for Tebel from Mushkan Wadwa. The question is, what if there is a warranty under the contract? Does that impliedly extinguish or waive the duty to investigate under Article 42 of the CISG?
It's an interesting question that also has, as many questions, no definitive answer. I mean, it very much depends on the interpretation of what the parties actually agreed in their contract. There are many contracts which contain quite comprehensive warranty clauses, and which then also provide for the exclusion or derogation from any warranties or indemnities under the otherwise applicable law. If that would be the case, then obviously Article 42 would be done away with regard to this particular contract. If not, I think it would be difficult to argue that the mere provision for the seller's liability for encumbrances of the goods with intellectual property rights would have a different scope than the otherwise Article 42. So there has to be language in the contract indicating an intent of the parties to modify the standard of Article 42.
Thank you very much, David. Okay, another question for David is there a minimum seriousness of a claim, a requirement under Article 42 of the CISG?
Yes, I've also, again, a very interesting question, which is debated in literature, at least. I've briefly touched upon it in my presentation. The majority view is no, there is no such minimum standard. Also, obviously unfounded and even frivolous claims are encompassed by Articles 41 and Article 42 and trigger the seller's liability as a matter of principle. Obviously, if you look at the various other requirements that actual liability then has, there are certain requirements which might nevertheless stand in the way of a successful claim of the buyer. For example, the seller might not know of the frivolous claims, and in many cases the seller will not know if the claim really just appeared out of thin air. Then there would be no way for the seller to know of it. But that also in itself is an argument for encompassing the liability for frivolous claims into Article 42, because if the seller knows of it at the relevant time, then I think it makes sense to hold the seller liable for it. Also on the side of remedies, to briefly add that, in case of frivolous claims, in many cases at least, it is quite easy to fend off the claim. So there might, for example, not be any damages of the buyer, or there might not be a fundamental breach of contract which would be required to avoid the contract. So you see there are many, again, knobs and dials which are relevant with regard to a successful claim of the buyer. But as a starting point, these kinds of claims are encompassed.
Thank you, David. Laura?
Thank you all. With this, I think there is no more questions or comments. So with this, we finish the round of questions and comments from the public. Thank you for you all for your participation and interest in. We thank everyone for listening to our guests who have discussed relevant issues, not only to the Camp Santiago Vis Moot and the Willem Vis Moot, but
I think we lost Laura's connection, but yes, to resume, we want to thank you everyone for listening to our guests who have discussed relevant issues not only to the Camp Santiago Vis Moot and the Willem C Vis Moot, but also to the lawyers engaged in international commercial arbitration all around the world. We hope that it has been very helpful to you all. Certainly, we thank our guests of today for such comprehensive and interesting conversations, for the time and their interest in these actual topics. We hope to see you soon, and we wish you the best. It's now up to Laura, I think, to introduce the issues discussed in this year's Vis Moot problems.
I'm so sorry. I think my connection failed. that kind of things happens, right, in this kind of virtual meetings, but I didn't know what happened. I was really inspiring talking about this, but now I would like to say some words to close this, and thank you again for all your support. The participant teams in this year's second Camp Santiago Vis Moot will be discussing these topics facing tribunals of high level. For our Vis Moot, we invite arbitrators from all over the world with the vast experience in joinder under the Swiss rules, remote hearings, and their impact on the procedural rights of the parties, applications of the CISG, non-conformity, and international commercial arbitration in general. We are glad to announce, this is really important for us, that among the confirmed arbitration for our pre-moot, 53% of them are women. We consider this an important step in the path of the academic and professional inclusion of women in international commercial arbitration. And we working really hard to be more inclusive in this kind of things. With that being said, we wish you the best in your pleadings next week and hope you find them helpful and challenging for your preparation. Also, I would like to thank Mr. Juan Eduardo Figueroa. I saw your comments in the Q&A. He's an arbitrator of our center. So this is really great because this show us that this not only interested to the participants of the Vis Moot, to also to our arbitrators in the Camp Santiago. So see you next Monday. Have you all a great day. Again, thank you, Patrizia, Giacomo, Xavier, David. David, you will be, for us, it's really grateful that you being here because we have some problems with another speaker that had a family inconvenience. So you be really, 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 really good with us and kind to accept our invitation. So no a really long terms to be in this conference. So thank you very much to all. Do you want to say something, Claudio?
I want to thank Patricia, David, and Giacomo. Thanks especially to Patricia for organizing again the Vis Moot. I think it is a magnificent experience, not only for students, but also for the arbitrators and young professionals. So thank you, Patricia, from Chile.
Thank you very much. I hope to see you in 3 weeks at the Vis Moot. Again, that would be wonderful. Thank you.
Thank you very much to all of you. And we finished. Giacomo, you want to say something?
Just thank you, Laura and Claudio, for the great organization and for having me today. Thank you very much.
We're really happy to have you. Like I said, grazie mille per il tuo tempo.
I can only echo that. Thank you for the invitation. Also on short notice, it was a pleasure to be here. And thank you for the great organization. Thank you, David, really.
Thank you all. See you soon. Next Monday, we start with the general rounds and we finish the 12th March. Thank you very much and have a nice day.